The Supreme Court has just detonated a legal earthquake, one so sudden and so forceful that it has ripped the ground out from beneath Donald Trump. The former president, long accustomed to controlling the narrative, now finds himself stunned, exposed, and scrambling for footing. This is not a routine courtroom setback. This is a moment of rupture, an unexpected turning point that virtually no one outside the highest levels of the judiciary anticipated. And for Trump and his legal circle, the implications are nothing short of catastrophic. What we are witnessing is history unfolding in real time. A hidden process operating far from public view has abruptly emerged into the open, leaving Trump's camp visibly shaken. Reports suggest confusion, panic, and disbelief spreading through his inner circle as the reality of what just happened begins to sink in. Before we break down how this stunning legal blow landed and why insiders say Trump himself is spiraling, take a moment to subscribe, turn on notifications, and hit the like button. If you want direct, unfiltered analysis of these courtroom battles, the details most outlets gloss over or avoid entirely, you're in the right place. Join this growing community now, because the next 72 hours may prove to be some of the most consequential of Trump's legal life. Now let's examine the structure of this devastating ruling. In a move that constitutional scholars are already calling extraordinary, perhaps unprecedented in modern American jurisprudence, the Supreme Court has ordered Donald Trump to immediately surrender a sweeping collection of materials. This includes financial records, internal business communications, and highly sensitive documents that, according to reports, even members of his own legal team did not realize were within the court's reach. There will be no delays, no obstruction, no procedural maneuvering. Compliance is mandatory. This was not a routine rejection of a motion or a quiet procedural decision. This was the nation's highest court tearing away a curtain, revealing that something significant has been hidden in plain sight. For more than a year, a sealed grand jury investigation has been running in total secrecy, parallel to every prosecution the public believed it knew about. And now, Trump has been legally compelled to hand over evidence that could expose an entirely new and previously concealed layer of criminal risk. The sheer scale of this revelation is difficult to overstate. The Supreme Court managed to oversee proceedings of this magnitude for months without any public awareness, no leaks, no headlines, no hints. What unfolded was a covert legal confrontation conducted entirely behind closed doors. A silent battle so deeply buried that even Trump's lead defense attorneys reportedly did not learn of its existence until the ruling was finally issued. There were no televised oral arguments, no media advisories, no advance signals of any kind. Trump's media apparatus had no opportunity to shape the narrative, and his legal team had zero time to prepare a counterstrategy. One moment, Trump believed he had mapped every legal threat surrounding him. The next, the ground collapsed beneath his feet, dropping him into a legal abyss he didn't even know existed. And this is not simply about adding another case to an already crowded docket. The Supreme Court has now confirmed that a covert investigation was unfolding the entire time, one involving material so sensitive, so potentially consequential, or so deeply tied to national security that even the existence of the subpoena remained classified. The fallout from this sudden exposure is poised to fundamentally reshape what we thought we understood about Trump's legal vulnerability and his political future. The sealed process. To truly understand how explosive this ruling is, we need to examine just how extraordinary this type of Supreme Court action really is. Under normal circumstances, the court stands as the pinnacle of judicial transparency. Cases appear on public dockets. Oral arguments are scheduled months in advance. Legal briefs are filed openly. Secrecy is the exception, not the rule. Yet the court retains a rarely used power, the authority to conduct proceedings entirely under seal. This mechanism is reserved for the most extreme circumstances, grave national security threats, or other interests so sensitive that public disclosure itself could cause serious harm. Historically, it has been invoked sparingly, typically in cases involving top-secret intelligence or active counterintelligence operations. That the Supreme Court chose to invoke this authority here speaks volumes. According to the ruling released on December 7th, the sealed process began more than a year ago when a grand jury issued a subpoena demanding Trump's financial records, internal business communications, and documents tied to matters of profound national significance. Because the subpoena was issued under seal, Trump was served quietly and placed under a strict gag order. He was legally prohibited from revealing its existence to the public, his allies, or the media. His attorneys were bound by the same uncompromising confidentiality rules. Trump challenged the subpoena through sealed filings, relying on familiar defenses, presidential immunity, and executive privilege. But this time, the strategy collapsed. The trial court rejected his arguments. The appellate court did the same, and now the Supreme Court has delivered the final blow, rejecting his claims outright and ordering immediate compliance. Chief Justice John Roberts' opinion is direct and unsparing. It states that the subpoena targets conduct that falls wholly outside any credible claim of presidential immunity, and that Trump's attempts to delay and obstruct have already been fully litigated. No further postponements will be tolerated. Legal experts note that this investigation appears entirely separate from the classified documents case in Florida, the January 6th prosecution in Washington, and the Georgia election interference case. This is a distinct and independent front, a fourth major legal battlefield that emerged without public awareness. The deadline: this is where the situation becomes truly perilous. Trump's usual legal playbook, attack the process, delay the outcome, run out the clock, offers no protection here. The subpoena has been challenged at every level. There are no remaining appeals. The Supreme Court's decision is final. The timeline is unforgiving. The court has imposed a firm compliance deadline of exactly 72 hours from the moment the order was issued. Not weeks, not days, 3 days total. In unusually blunt language, the court warned that any failure to comply fully and in good faith will trigger immediate civil and criminal contempt proceedings. Potential consequences include pre-trial detention. In plain terms, attempts to delay, obstruct, or submit partial records could result in incarceration before a trial even begins. This language reflects a judiciary that has reached the end of its patience. The message is unmistakable. Defiance will not be tolerated. The documents. So what exactly does the subpoena demand? First, prosecutors are seeking complete financial records dating back to 2015. This includes all transactions involving foreign entities, loan agreements and their terms, and communications related to property valuations. The scope is sweeping, designed to uncover patterns of systemic behavior rather than isolated incidents. Second, investigators are demanding all communications between Trump and certain foreign nationals whose identities remain redacted for national security reasons. This suggests potential ties to foreign governments or intelligence networks, far beyond routine business dealings. Third, and most explosively, the subpoena seeks documents related to obtaining anything of value from foreign sources in connection with electoral activity. This language closely mirrors federal prohibitions against foreign involvement in U.S. elections, signaling a probe into possible campaign finance violations. Trump's legal team has just 72 hours to gather and produce materials spanning nearly a decade. The logistical challenge is immense. The legal risk is far greater. The meltdown. Reports describe chaos inside Trump's inner circle. Lawyers scrambled. Emergency meetings were called. Trump himself reportedly erupted, lashing out at his attorneys and publicly attacking the Supreme Court. He took to social media, questioning the legitimacy of the ruling and suggesting he would refuse to comply. Legal experts immediately warned that such statements could be used as direct evidence of willful defiance. Former federal prosecutors described Trump's public remarks as an invitation for contempt proceedings. If he refuses to comply, intent would not need to be proven. He has already declared it. Some attorneys are reportedly considering withdrawal, concerned about ethical exposure and lack of full disclosure. Any departure at this stage would be devastating, with no time for new counsel to prepare. The consequences, the broader implications are profound. The demand for extensive financial records suggests a far-reaching investigation into potential corruption, foreign influence, and systemic misconduct. The national security dimension raises counterintelligence concerns, and the election-related requests strike at the heart of democratic integrity. Legal scholars are already calling this the most consequential Supreme Court action involving a former president since United States v. Nixon. The court has demonstrated that even former leaders are subject to confidential investigations and swift enforcement once the judicial process concludes. Politically, the fallout is immense. Trump's claims of persecution now collide with the reality in which compliance is mandatory and secrecy has worked against him. Here is the reality. A secret grand jury investigation has been underway for more than a year. The Supreme Court has ordered immediate compliance within 72 hours. Failure could result in jail. The clock is ticking. No matter what these documents contain, the truth is now on the brink of exposure. This is a decisive moment, one unfolding faster than anyone expected.